let's continue with the laws by looking at some of the export and espionage laws. The EEA, or the Economic Espionage Act, was passed in 1996 to protect companies from foreign governments using their spy apparatus to garner access to trade secrets. Now, this might be by embedding an employee that's a spy in your company and stealing the material directly, or it could be influencing a disgruntled employee to download the material to a thumb drive and bringing it out of the company. I've seen cases using both techniques. So it's important to understand that there really are people who want to steal the data that you are protecting. And in many cases, they'll go to great lengths to get access to that because it allows them to either produce another product that'll compete against your product, or underbid you, for instance, in a international proposal for a particular activity that your company might be bidding on. The Security and Freedom Through Encryption Act in 1997 provide guidance on the use of encryption and institutes measures of public protection from government intervention. It's actually interesting because prior to 97, encryption was actually handled under the ITAR laws, export of military technologies, and many countries prohibited the use of cryptography to obscure information that was being sent outside of those countries. Much of that has changed today, and in some cases it hasn't in some countries. But it's the Encryption Act specifically reinforces an individual's right to use and sell encryption algorithms without concern about the impact of other regulations requiring some form of key registration. There were, back in the early 90s, there were actually, government was trying things like give us part of a key and you keep part of a key, or we have to have the full key if you're going to encrypt and send anything out of the U.S. So that this law was an effort to clarify and to provide those rights to an individual and to companies. It prohibits the federal government from requiring the use of encryption for contracts, grants, and other official documents and correspondence. The U.S. copyright laws extend protection to intellectual property, which includes words published in electronic formats. It also provides the doctrine of fair use, which allows material to be quoted, for instance, in a scientific report or news reporting or teaching, etc., as long as the purpose is educational and not for profit, and the usage is not excessive. So, for instance, I can't copy an entire book and give it to the student and say, here, use this in your class. But I might copy a page, or I might cite information out of a page or a chapter to, not a full chapter, of course, but information gleaned from a chapter that could be used in the educational process. So, proper acknowledgement must be provided. You have to cite the author and the work, as that author's effort has been really put together to be able to generate that work, and copyright protects that. Freedom of Information Act, or FOIA, 1966, requires government agencies, when they receive a FOIA request, to disclose records that an individual wants to have access to. The FOIA applies only to federal agencies and does not create a right of access to records held by Congress, the courts, or by state and local government agencies. So you can't go to the Plano city government and file a FOIA request and say, I want to see all the records pertaining to your use of funds for some project. However, you can go to a federal agency and apply and request using FOIA for information that agency might be working on. Each state has its own public access laws, and those should be consulted for access to state and local records. Sarbanes-Oxley was designed to enforce accountability of financial record keeping and reporting at publicly traded corporations. So you might say, well, how does that apply to information security? Well, it requires the CEO and the CFO to have direct and personal accountability for the completeness and accuracy of the company's financial reporting and their record-keeping systems. So part of that is the infrastructure, the IT, that goes around protecting those records. So we have what are called IT general controls, which do include a component of information security in them, as it's your function to protect access to that delicate information, the financial reporting, as well as the information that might indicate whether the records are complete and accurate, though that's really the financial department's responsibility. You may be able to see whether things have been changed through logs or whatever that you may maintain from a security perspective. The data breach laws, so there are now 50 states' data breach laws. Each specifies a requirement for organizations to notify affected parties when they've experienced a specified type of loss of information. In other words, when a company that operates in a particular state is breached, there is a duty imposed upon your company to disclose that you have lost information through a breach. Now, keep in mind, most companies, when they sell products or interact in the United States, act across many state boundaries, and there may be data on individuals that are across many of those state boundaries. So you may find that you have disclosure responsibilities across many different states. And this is where the legal department and information security can work together to determine what was stolen, how much was stolen, and the states that may have been involved in that process. Each organization, each state defines what the reporting requirements are and defines what their penalties will be if you do not provide a timely response to being breached. Right now, there is no federal law or a national law regarding breaches, but we may get to that point, and there's pros and cons to whether or not that's a good thing or a bad thing if we have to actually do a federal law. There are many international laws that we also operate with. Many companies operate only in the United States and have no international impact in their operations. However, some may have a hidden impact. For instance, I may have sales to people who live in Europe, so that may make me subject to the General Data Protection Act, the GDPR, for instance, in Europe. But these international laws have many complexities, and you need to really understand how they might impact your operation. So we'll look at just a couple and give you some idea. So the European Council of Cybercrime Convention empowers an international task force. Many of the European Union countries participate to oversee a range of internet security functions and to standardize technology laws internationally. Now, that all sounds very good, but it develops basically a number of laws, a general set of laws that each of the European states adheres to. The overall goal of the convention was to simplify the acquisition of information for law enforcement agents and certain types of international crimes, as well as the extradition process. What it also did, though, was create a situation where you had those general laws applied across all the European nations, and then each nation added their own set of laws on top of that to make it even more complex. The Digital Millennium Copyright Act, or DMCA, is an international effort to reduce the impact of copyright, trademark, and privacy infringement, both in the U.S. as well as internationally. It's especially the removal of technological copyright protection measures. The European Union created Directive 95/46/EC, which increased individual rights to process and freely move personal data, but that was supplemented later by the GDPR, or the General Data Protection Act. The Australian High-Tech Crime Act is Commonwealth Legislation Part 10(7), Computer Offences of the Criminal Code Act 1995. Specifically includes data system intrusion such as hacking, unauthorized destruction or modification of data, actions intended to deny service of computer systems to intended individuals such as denial of service attacks, distributed denial of service attacks, and creation and distribution of malicious software. So this law, we look at this law as sort of a model law when you're looking at many of the things that hackers or people who are looking to disrupt your network through the internet might in fact use, those techniques that they might use. And again, this came out in 1995, so it was really forward thinking in how to protect computer systems against attacks across the internet. As I said, each state has its own state and local regulations. So as a security professional, it's important that you understand within your state, within your municipality, what are the rules that where information security may be covered under state laws. Well, certainly each state has data breach laws, privacy laws perhaps, and in this case we're looking at the Georgia Computer Systems Protection Act, which has computer security provisions and provides penalties for the use of information technology to attack or exploit information systems in other organizations. Also, the Georgia Identity Theft Act requires that businesses may not discard a record containing personal information unless it's shredded, erased, modified, or otherwise makes the information unretrievable. So this is just an example of one state, for instance. And if you were living in Atlanta, for instance, you might want to determine if Atlanta has any specific information security requirements. Standards versus law. So a variety of groups have established standards that offer guidance on how information security could or should be applied to industry segments. One of the more pertinent ones that I've worked with in the past was the Payment Card Industry Security Council and the PCI, or Payment Card Industry Data Security Standard. And you'll hear this referred to commonly as the PCI DSS. And this is a set of industry standards that are mandated for any organization that handles credit, debit, or specialty payment cards, and particularly any organization that stores, transmits, or processes any of that data. The current standard, 321, is presented by the PCI Securities Councils as focusing on 12 requirements in 6 areas, and we'll look at those shortly. Something to keep in mind with the PCI, though, is it changes about every 18 months. It's appended as new criteria are applied, and it's upgraded about every 36 months. So you'll see version 4 of this come out very shortly. But you can go to PCISecurityStandards.org, and it will have the latest version of the laws out there for you. So here are the components of the PCI DSS. secure network and systems development and maintenance, firewalls, and some of the administrative security tasks that you normally are associated with, passwords and configurations. Cardholder data protection, general protection of cardholder data storage. My favorite is 321. Don't store card data if you don't need to store card data, and certainly do not store the whole strip, the whole on the back of the card. Use of encryption when transmitting card data, vulnerability management, and program maintenance. Section 5 is mainly malware and antivirus protection. 6 is protection of applications and their development and maintenance. Strong access control measures need to be implemented. Network monitoring and testing. This is where you'll do a number of things like vulnerability testing, penetration testing, and tracking down data that tracking down vulnerabilities in your system. And then information security policy maintenance, establishing an information security policy and the management and protection thereof. Benefits of the PCI DSS as promoted by the PCI Security Council include protection of payment cards, make sure they're secure, which then promotes trust from your customers, improved reputation with payment card issues and payment processing organization, prevention of security breaches, assistance in complying with other security standards such as HIPAA, SOX, and JLB, support for organizational security strategies, and increased efficiency in information infrastructure. Because policies function like laws, they must be crafted with the same care as laws to ensure that the policies are complete, appropriate, and fairly applied to everyone in the workplace. The key difference between a policy and a law is that where ignorance in the law, ignorantia juris non excusat, is not an excuse, ignorance of a policy might be a viable defense. So policies have to be distributed to all individuals in your organization, and all individuals must be expected to comply with them. They have to be read by all individuals, understood by all individuals, and so if you need multilingual translations, those have to be provided. They have to be acknowledged by the individual, usually by a signed consent form, uniformly enforced, and no special treatment for any group and no individual. In particular, executives, management, and every employee must engage the policy the same way.